Okay, I want to welcome everybody to today's meeting. I know we've got a lot more on Zoom than we have in person today for various reasons. I appreciate everybody being here. Jack has had a conflict, but he's supposed to be coming in later if he can be cleared up from that. Start out by reading the Ethics Awareness Conflict of Interest Reminder. In accordance with the State Government Ethics Act, it's the duty of every board member to avoid conflicts of interest. Does any board member have any known conflict of interest with respect to any matters coming before the board today? If so, identify the conflict and remain from participation in the particular matter involved. Anybody have a conflict?
No, sir.
No.
All right. Then we'll carry forward to the public comments section. Before I recognize anybody, I want to read this about the public's comments. Before we begin the public comment portion of today's meeting, I'd like to review the guidelines for participation. Each speaker is limited to 5 minutes. Please state your name for the record before beginning your comments. Speakers are expected to address the board respectfully and confine remarks to matters within the board's authority. Please be advised that this is a public comment period. While board members may be present and listening, questions directed to individual board members will not be answered during this time unless permission is granted by the chair. The purpose of this segment is to allow the board to hear from the public, not to engage in dialogue. The chair reserves the right to enforce time limits and maintain order to ensure that all participants have a fair opportunity to speak. Thank you for cooperation. Do we have anybody who would like to speak?
Hello, my name is Kenneth Wayne, license number 2137. To the board of the executive director of Legal Counsel. I will begin by addressing the vote on Rule 802. My objective in every proposal and every complaint that I have filed has been a single and consistent standard. Every licensee in North Carolina must be treated equally under the law. While I am glad you finally moved towards that standard, the irony is impossible to ignore. The chair now claims that he would not want to be in any profession where you stop learning. Yet he has been at 57 meetings, at which most of them he was the chair, where this exact dangerous precedent was the status quo. It is a remarkable epiphany to have only after the exception becomes a clerical burden for the staff. This brings us to the total collapse of the body's decision-making process. At the start of the last session, the chair established a clear mandate to keep discussions, quote, as limited as possible, so everyone could, quote, get out of here. By the end of the same meeting, he confirmed his success, stating, quote, I have rushed through this to get this done as concisely as I can. The leadership of this board, that is not efficiency, it is confusion. I'm sorry. That is not efficiency, it is a confession. The personal convenience of the entire administrative body is not legal substitute for the North Carolina Administrative Procedure Act. The minutes state public comments were provided to you in advance. To be certain, I emailed the request exactly what was information the board was given prior to the vote. If you had the materials, then the confusion displayed during the last session was a choice. Whenever I complain about the board's verification site, the response is always a deflection, a promise to contact the vendor. It is an illusion of action. As of today, if you were to go to the site and enter my license number, the most critical number required by law to be on every piece of my advertising, it returns 0 results. I challenge any member of this assembly to go on that site right now as a member of the public would and try to verify my license. You are forcing licensees to display a number that your own system renders worthless. If the board truly cared about informing licensees, they would prioritize enforcement over convenience. When the board asked me to supply a list of non-compliant advertisers, I provided 80 specific names. Instead of sending formal enforcement letters, the board chose the easy path, a general newsletter. The result, only 9 of those 80 violators updated their websites. This is a failure rate of nearly 90%. We saw it again when the chair read the title of the proposal regarding advertising by exempt entities and immediately stated, quote, "The title itself tells you we can't do it." Not once did legal counsel, the director, or a single member of this assembly attempt to correct him or even ask what the actual text stated. Instead, the chair anchored every vote by giving his personal opinion first, directing the outcome before a decision could even start. I have one final question for everybody. Can you honestly say under oath of office that you read the public comments and the full text of these proposals before you voted? The record shows an uninformed group merely following a rushed narrative to the exit. The details of these 26 counts of administrative failure are documented in the dossier I am handing you today. I expect it to be included in the permanent records for legislative review. Thank you.
Appreciate your comments, Wayne. Anyone else want to provide any public comment? Hearing none, we'll go to the next item, which is approval of the agenda. Have a motion for approval? Motion approved. Have a second? All those in favor?
Aye.
Aye.
Any opposed? Agenda's approved.
Yeah.
Next thing will be approval of the previous meeting minutes.
Move to approve previous meeting minutes.
All right, David's second.
Second.
All right. All those in favor?
Aye.
Aye.
Any opposed? Minutes are approved. Next will be the approval of the financial report.
I'll make a motion.
Do we have a second?
Aye, second.
All those in favor?
Aye.
Aye.
Any opposed? All right. The financial report approved. Next thing I'll turn it over to legal for board training and some votes.
Yeah, thank you. Hi, everybody. It's good to see you, those on the screen and those here in the room. We have 2 items under our legal report to cover today. The first being our annual board training, really it's biannual. We have to do this every 2 years for our board members. We call this our 93B training. It's going to cover topics of law that you are required to know as board members by statute. It takes about 30 to 45 minutes. You've all been sent the PowerPoint presentation in advance of this meeting, so you're welcome to follow along as we work through those laws and those materials for short. The second thing that we've got on our legal report agenda is just a vote on the rules that were sent to you yesterday in your packet. I know that we had some votes taken at the last board meeting on those. The documents that were emailed to you in the final version of those texts as we prepared, directed by your vote. So we'll take one more vote to accept them as written to make sure it reflects the decisions that you reached at the last board meeting. And then we'll move forward with filing those at OAH. So before I launch into those 2 items, though, I will just give you a quick global legal update. We do have 2 matters currently pending in the general courts that were directed by the board for us to, in which we were directed to seek a preliminary and permanent injunction against 2 unlicensed individuals for whom we've obtained evidence to show that they've engaged in the unlicensed practice of law defending. We have the first one being for Joseph Trammell, the court granted our motion for default judgment on the permanent injunction on March 25th. So right now we've got a proposed order pending signature with the court. The second against Brad Shiner. We have filed a complaint against Mr. Shiner toward the end of February. We're still in the process of trying to serve him with that complaint, as it appears he's somewhat transitory at that time. So our service efforts are ongoing as we sit here today. Anybody have any questions about that before we launch into the 93B training?
No.
All right, terrific.
No.
All right, so. Andy. A lot of this will be familiar to you for those board members that were with us back in 2024 when we last reviewed these materials. As a reminder, we're here because the general statute tells us to cover these topics, and they are all topics that board members are required to know and implement in their board meetings every time we get together. So it's always good to have these refreshers, and then if we have questions as we go through it, I welcome you to interrupt me, but ask the questions that may be on your mind, the practical implications for some of these laws. These trainings tend to be a lot more interesting when they're interactive, so please do speak up. We can talk through any real life situations that you have questions about. So we're going to start with saying, what is the board? Right, that's the big question. Who are you guys and what are you doing here? Powers of the board are set forth in general statute in 74F-6. You have certain enumerated powers, certain enumerated responsibilities that are set forth by the General Assembly. Types of things that you are to be doing to regulate the profession. And you also have your administrative code, your rules that this board promulgates in Title 21, Chapter 29 of the Administrative Code. So that's where you go to see what authority you have to do the things that you do. This board is comprised of 9 members, 3 of whom are appointed by the governor. Those are public members, not licensed. 3 appointed by the Senate President Pro Tem of the General Assembly, who are licensed, at least one of which has come from a represented recognized locksmith organization in the state. And then 3 members are also appointed by the General Assembly. The Speaker of the House of Representatives makes that recommendation. Those members have to be licensed locksmiths, and at least one of them has to be represented by a recognized locksmith organization of the state as well. That's what the statute requires, and that's your composition. There is an additional qualification that all members have to 5 years experience in locksmith services, engaged in that business for the duration of their time on the board as well. So the next question, where does your funding come from? As I'm sure most of you are familiar based on our review of the budgets in each board meeting, this board doesn't receive any funds from the state treasury. You're not supported with financial appropriations from the state. The board is entirely funded from licensure fees that obtains through the application process of applicants seeking a locksmith license. It also comes from the examination fees as well that are allowed to be charged pursuant to statute. So self-funded, we have to set those fees up to our statutory cap that's dictated by the General Assembly. And we set those fees through rulemaking anywhere from 0 or up to the statutory cap is allowed by the General Assembly. So we talked about the statutory authority. You've got to take certain actions where you look to your authority in the statutes and rules. So then the question is, well, what is the primary purpose of the board? You've gotten your authority, you've gotten your funding, but what is the primary mission of what you do? And the short answer is your job is to make sure that anyone seeking entry into the profession of locksmithing or currently holding a license engaged in active practice meets minimum competencies that's set by the General Assembly. So it can get fine line. Sometimes we see folks who may not be doing as we think they should. They may not be perhaps implementing best practices. It's important for us to remember that our mission is not to regulate best practices, but make sure we've got minimum competencies as those competencies are decided by our government company. So how do we do that? We do it through credentialing. We do it through the initial licensure process and criminal background checks. We do it through discipline when folks who have obtained a license aren't doing as they should, and there needs to be some regulatory oversight and further supervision set forth by the board. We do that through interpreting and enforcing our statutes and rules, including a periodic review of our existing rules to see what needs to be updated or revised as the practice of locksmith continues to evolve. We also do that through submission of many governmental reports. Martin can certainly speak to that. This time of year is a busy one in particular. Probably 12 to 15 different types of reports the board has to submit throughout the year. Various agencies within state government, HHS for child support, NCDOR for licensure records, the Administrative Procedure Oversight Committee, the GovOps Committee within the General Assembly. Lots of different information about what we do and how we do it gets provided every year to those oversight organizations. And lastly, as you know, we also can proceed as the general courts to seek injunctions or contempt proceedings from time to time as well. So we not only touch the folks who are coming to us for licensure who have attained a licensure, but also those who have not but should have, to make sure that we're doing our best to bring about compliance with the general statutes. So, what does our profession look like? Who is it that we can issue licenses to? Well, we've got the applicants, we've got apprentices, and we've got fully credentialed locksmith licensees. Who we issue a license or an apprenticeship to is dictated by statute. It's set forth in 74F 7 and 7.1. We have to follow those guidelines, those criteria when deciding whether someone is eligible for licensure or not. And we do that through our application process, which is codified in rule, requiring applicants and licensees on their renewal applications to submit certain information every year that the board verifies, reviews closely to make sure that they're still fit to practice. So that's just a little bit about the board specifically. I'm going to touch for just a moment on the State Government Ethics Act. But when I say for just a minute, I really mean just for a minute, because as board members, there is a separate ethics training course that you're required to take through the Ethics Commission that this training does not cover. And so Barton is your ethics liaison, is your primary point of contact to let you know when those dates for re-upping your ethics training come due. And I know as he's told you, you've got your SEIs coming due just a couple of weeks, April 15th. So if you've not submitted those yet, please talk to Barton about how to get that done. So my purpose of bringing up the State Government Ethics Act is just to remind you that it's there, that you need to take that separate training. It's a body of law that dictates how board members are to conduct themselves in navigating through potential conflicts of interest, what may be a conflict of interest, what may be an appearance of a conflict of interest, so that you can avoid any perception of a potential bias that may come about through your conduct of board business at each board meeting. Your primary obligations when thinking about ethics at the board meetings is to keep an open mind on all matters coming before you for a vote, and to avoid those conflicts or appearances of conflicts of interest. Follow those two things, then you'll be in pretty good shape. As you know, there is some reimbursement rights that you have to seek for some of the board work, for per diem or travel reimbursements, and those are all set forth in statute as well. Okay, so with that said, let me turn to the topics that this training will cover, since I've told you what it won't cover. 93B5 sets forth 6 different bodies of law about which you're to be trained that we'll go over today. The first being Chapter 150B of the General Statutes, that's the Administrative Procedures Act, that covers obligations with regard to rulemaking and how contested case hearings are to be conducted. Chapter 132 covers public records laws. Article 33C of Chapter 143 covers the Meetings Act. Article 34 and 34A of Chapter 143 covers the State Tort Claim Act and the Defense of State Employees Law. Chapter 138A covers the State Government Ethics Act, and Chapter 120C covers lobbying laws.
I think we're up to.
All right, so let's start with the APA. And the first article within the APA, Article 2, is the one that covers rulemaking. This APA article sets forth a uniform system governing administrative rulemaking, hearings, and appeals. And it has very detailed guidance to you about how rules are to be promulgated, specifically different types of rules and how they may be promulgated from time to time. So the board has an obligation in statute to review those rules periodically, and when it does so, it's supposed to be looking to see whether any of the rules are unnecessarily promulgated, whether they really, there's not a necessary need for them to be in the code, or whether they impose unduly burdensome requirements on the regulated public. The board should also be looking to see whether those rules are inconsistent with the guidelines of the APA, such that they're not written in a clear and unambiguous manner, that they're not designed to effectuate the purpose in a cost-efficient or timely manner, or to the extent that they're just not up to date with the current statutes. You know, rules can get stale and can age, particularly if the statute has changed and the rules haven't been brought up to meet the current regulatory scheme set forth in statute. So it's important to look at those periodically to make sure that they are intending for the purpose for which they were promulgated, and that's to implement and interpret the current statutes that are in the general statutes. So in addition to that annual review of the rules that the board is aspirationally encouraged to do, there is a mandated periodic review process every 10 years, and we're in the midst of that right now. And the periodic review process requires the board to look at every rule that's on its books and designated it as either necessary or unnecessary. Post those initial determinations for a public comment period of at least 60 days. At the end of the 60-day public comment period, then reach a final determination on whether those rules are necessary or unnecessary. And then for those rules that are deemed necessary, the board is set forth on a readoption schedule to have the board take all of those necessary rules back through the rulemaking process with any updates that it thinks is necessary at the time, and republish the rules, readopt the rules. So we're in the midst of that right now. As you know, we have finished the final determination process that's been approved by the Rules Review Commission, and right now we're just waiting to hear back from the Rules Review Commission staff attorneys on our required consultation on when our readoption deadline will take place. It's probably going to be a couple of years out that they put the readoption deadline in place, but that doesn't mean we can't start the process now. And so we can talk about this later on the agenda more as well, but this is probably the right time for the board to start thinking about a task force or a subcommittee to look at all of its existing rules, see what it wants to update. Now is the time. That's the purpose of the periodic review process. See what additional language needs to be in there, what needs to be removed, so that when our readoption process does start in the next year or so, we've got that ready to go. We can get around running. There's also certain requirements with regard to a financial analysis of rules that are promulgated to make sure they meet a certain financial impact on the regulated public, both positively or negatively within a certain threshold in a certain period of time that fiscal note is prepared. And we would work with OFBM to make sure that's done appropriately and with approval. Given the size of your board and the number of licensees that you have, it's very, very unlikely that any of your rules would ever make a fiscal note required for that purpose. You just don't meet the economic threshold for it. But it's good to know that it's there, so that if anything ever did come up, you're thinking about that, doing the right analysis to make sure that you don't hit a fiscal. There are certain rules that can be changed without the formal public comment period, the readoption process, and that is when some of the rules are really just either to fix typographical errors or to fix very limited things like the email address or a phone number for the board, or to correct a citation in a law that may have changed over time since the rule was promulgated. There is a mechanism for the board to do that with the codifier of rules without having to go through the full rulemaking process. So it's good to know that that's available to you as well. Going to talk to you for just a minute about petitions for rulemaking, which is something we've been familiar with recently in the last few board meetings. We can accept petitions for rulemaking from anyone in the state, anyone who maybe have a stake in the types of rules that this board promulgates. And upon receipt of a petition for rulemaking, the board is obligated to look at it carefully, make sure all of the things that are required to be in the petition are in fact there as set forth by statute. And then the board takes a vote on whether to grant or deny that petition within 120 days. When a petition is denied, there's a written statement with the grounds for denial, run it back to the petitioner. And if it's granted, then you initiate the rulemaking process, send out public comment, and then deliberate on at the end of that process whether or not the board wants to move forward with promulgation. There are different timelines in place for temporary rules and emergency rules versus permanent rules. The time frame I've been talking about so far is just for permanent rules because that's the most common type of rule that you would be promulgating as a board. But it's also good to know that, say you ever did get a statute change come through that would change any of your existing rules or make necessary new rules to be promulgated more quickly. There is a mechanism for that through temporary rulemaking when you've got a change from the legislature coming down. You also have the ability to engage in emergency rulemaking if it truly is an emergent situation that would require emergency action. Those are very few and far between. But just know that it's there so that you've got that option available to you if circumstances ever arise. Okay. Does anybody have any questions about rulemaking before I move into Article 3A of the APA? Okay. So Article 3A is the article in the APA that talks about the complaints procedures and how hearings are to be conducted by the board. The board has a fair degree of flexibility and discretion in deciding how to set up its complaint process internally, how it will accept and receive complaints from consumers, North Carolina citizens generally, or initiate staff generated complaints. This board has on its website a complaint form that individuals can complete and submit to the board, setting forth their contact information, a narrative of the transaction giving rise to the complaint, as well as their affirmation that they understand certain parameters surrounding the complaint process generally. And upon receipt of that, the board would review it with its ethics committee and make a determination whether it is going to dismiss the complaint, whether it will issue perhaps a non-disciplinary letter of caution, which would not give rise to a contested case proceeding, but perhaps would give a more formal advisement to the licensee of certain statutes and rules about which they need to pay better attention and put them on notice that they expect compliance with those statutes and rules going forward. Or the board can vote to issue a notice of hearing, which gives rise to the types of hearings that you heard at your last board meeting with disciplinary action against licensees. If the board votes to issue a notice of hearing, it has one of two paths available to it. It can either hear the matter itself in a board meeting and serve as the judge and jury for that disciplinary proceeding, reach a final determination in writing to be issued to the licensees. Or it could vote to designate the disciplinary matter to the Office of Administrative Hearings and ask that an administrative law judge be designated to take the evidence and make a recommended decision back to the board for its final agency decision. It's totally at the board's discretion I have some board clients who only take that secondary route, who never want to have a board hearing conducted themselves and want an ALJ to make a recommended decision to them. Other clients who prefer to hear it themselves, as the locksmiths in the room, they feel strongly that they're the best ones to interpret the statutes and understand the practice of locksmith, make sure their familiarity will help them reach the right case. Whichever path is taken, it starts with a notice of hearing being issued. And that is a document that is going to set forth the allegations, giving rise to the board's concern that a statute or rule has been violated. It's going to set the date and time for the hearing, the location of the hearing, the statutes and rules that are alleged to have been violated, and the possible sanction that could be taken against the licensee if the board finds those statutes and rules have in fact been violated. That's got to be served on the licensee at least 30 days in advance of the hearing, so they've got sufficient time to prepare for it. The licensee is not required to come to the hearing if he or she doesn't wish to do so, but they certainly have the opportunity, and it usually serves them well if they do come, because it's their opportunity to present themselves to you, to provide their sworn testimony, whatever documents and evidence they think is important for the board to know when the board is deliberating on the facts and circumstances of the case. There's certain commonality in the types of disciplinary actions that tend to come before you. The bases for which you can take disciplinary action, again, are all set forth in the statute. They're at 74F15. And there's 4 primary buckets of it. 1, that the licensee has given false information to the board or withheld information from the board in procuring or attempting to procure a license. The license or the applicant has been convicted of or pled guilty to or no contest to certain enumerated crimes that are set forth in your Practice Act. And those tend to be crimes like, crimes of violence, crimes of sexual misconduct, robbery, burglary, embezzlement, financial crimes of that type. But it's nice that you've actually got that listed out, because a lot of Practice Acts for other boards don't. So it helps you get a better sense from the General Assembly what types of crimes could be problematic in a potential bar of licensure as you review applications. The third bucket is if the applicant or licensee has demonstrated gross negligence, incompetence, or misconduct in performing locksmith services. It's a pretty big bucket, one that does take some independent judgment discretion from you in setting who knows the profession and can speak to the manner in which it was performed to reach those conclusions. And then 4, also kind of a big bucket, is a willful violation of any provisions of the chapter. So anytime the licensee doesn't comply with the other requirements for set forth in the Practice Act, you have a basis to kind of initiate disciplinary action against them. So let's talk about how hearings are actually conducted. So as I said before, if you take Path A, where you sit both as the judge and the jury during these disciplinary proceedings, it's really important for the board members to remember their ethics training and address any conflicts or potential appearances of conflict of interest on the record at the start of the hearing, so that you can put on the record that you're recusing yourself from the case. That means you won't participate in the proceeding or the deliberations on the outcome of the hearing. At the start of each hearing, your chair will read that ethics statement, give folks an opportunity to set their basis for recusal on the record. And that recusal is personal to you. It is your personal decision to make whether you think you've got the conflict or the potential conflict that would necessitate recusal. So we will look to you to make those statements. You're always welcome to confer with me or board staff in advance if you have any questions about it, but please know that is a decision that's yours to make. So you shouldn't wait for someone to tell you that you're recused. If you take Path B and you send the case to OAH and it comes back as a recommended decision, then that means that you would not be hearing the evidence of the case firsthand. You would not be looking the licensee or the applicant in the eyes while they're testifying to judge necessarily their credibility in the same way that you would if it were coming back to you in a recommended decision. you still get the opportunity to consider all of the evidence that was presented to the ALJ. You would get back what's called the official record. It would have a transcript of the proceeding. It would have all of the exhibits that were introduced into evidence, so that when you take back that recommended decision from the ALJ, you can be fully informed about the case. And so if the board ever elected to do that, it came back with a recommended decision, you would have that official record in front of you, the opportunity to go through it carefully, to read everything before you decided whether or not to accept the recommended decision or not. You're not required to. If it came back as a recommended decision, you'd have the option either to accept it in whole as issued by the ALJ. You'd have the option to modify the decision, so you could change certain findings of facts or recommended findings of facts, recommended conclusions of law, tweak the discipline that's recommended. Or you could reject it entirely and do a completely different final agency decision. It is truly just a recommendation to you. So you still retain that final say in decision-making authority, even if it goes to the Office of Administrative Hearings first. If the board elects to have hearings conducted here without sending it to OAH, there's a couple of important rules to keep in mind. One is that after a notice of hearing has been issued, that you cannot engage in what's called ex parte communications with either board staff or with the licensee outside of the presence of the other party. So it could be a little unusual when you're used to being able to talk to your legal counsel about anything involving legal matters before the board. So I want you to know, don't be offended if you ever tried to reach out to us about a notice of hearing, or if you've heard a notice of hearing had been issued, got a call from somebody, for us to say, we can't talk to you about that, it would be ex parte communication. And so if we needed to have a conversation, it would be in the presence of the licensee or applicant involved, so that everybody is looped into those conversations. It's important to avoid bias, and that can be a tricky thing to maneuver. So, because it's a small community, it's a tight-knit community, there may be locksmiths or applicants that come before you from time to time for a hearing, and you'll ask yourself, oh gosh, I know this person, I need to recuse myself. Just simply knowing somebody generally is not going to rise to something that is an appearance of a conflict of interest. It's usually something maybe a little bit more, like perhaps they practice in the same geographical area as you. You may overlap in territory a bit. You may have had some personal transactions in the past that if one were to look at it, they'd say, oh, you might have an axe to grind here, or you may be trying to do this person a favor by voting a certain way. Those are the types of things that you should think about when deciding if you need to recuse yourself to avoid that bias or potential for bias. It's important to come in with an open mind. We never want you to assume that we've got everything right just because we're representing board staff come before you with a case. It's really important that you hear everything that the licensee or the applicant says on the other side of the table. There may be information they haven't shared with us previously that's really important to the case that we're hearing for the first time too, and it may change the way you want to decide a particular matter. So always keep an open mind. Give everybody a fair shake. And don't reach any preconceived notions just by reading the notice of hearing that's in front of you. Also, don't seek outside information related to the hearing. In this digital age, it can be really tempting to have your cell phone right beside you during a hearing. You hear something that didn't quite make sense and do a quick Google search on the licensee or his business or the consumer involved. Can't do it. Yeah, put the phones away and only take in the evidence that's presented to you in the context of the hearing. That is your official record. That is the basis on which you need to be making the decision. And if you take in outside information that's not in the official record, it can skew the process. And ultimately, at the end of the day, what we want more than anything else is a fair trial, a fair adjudication that is defensible to the licensee and also to the general courts if the licensee chooses to appeal the decision. And then the last rule I'll leave you with is to show the same decorum to the licensees that you would expect a judge in the court of law to show to the licensee or the applicant if that person were going down to the courthouse for their hearing. It's tough sometimes when we're in an informal setting like a conference room in a law office, right? not all wearing suits and ties and the fancy courtroom stuff. But a good rule of thumb is try to put yourself in that person's shoe. If they were coming before the board to present their case, how would they expect their adjudicator to come across? You're all extremely professional folks, and I'm in awe of you every time you have these disciplinary cases, because I know they can be hard. They can be really frustrating sometimes, trying. But exercising that professionalism and really giving them these licensees and applicants the grace to tell their story as best they can goes a long way to making sure that the hearing is conducted in the most defensible way. Okay. So that's really your role as the judge and jury for these disciplinary proceedings. I'll tell you a little bit more about the process behind the scenes that you may not see as much of. There's a lot that goes on before a hearing even gets to you, before you see the evidence presented. We often try to engage in informal settlement negotiations if we can with the licensees or applicants in advance of the hearing. It's an aspirational goal that's set forth in the APA that boards are encouraged to try to engage in informal settlement resolution before a contested case is held. And we do that with these folks as best we can. There's a process by which the parties can engage in discovery in advance of the hearing. So either side has the opportunity to issue subpoenas for records, issue subpoenas to take depositions, conduct discovery of third parties through subpoenas, so that both sides have a mechanism to gather all of the relevant information that need to take their position in the hearing appropriately. After the hearing is concluded, then the board issues a written decision. Sometimes the board is able to reach a decision immediately after the hearing and orally provide that ruling to the board staff and to us, which we would then memorialize in writing for signature. Sometimes the board may need to take some extra time to deliberate on it. If it's a particularly complicated case, the board can request that a transcript be prepared, get back the written transcripts, deliberate on that a little bit more before they reach a final decision. So it's not imperative that a decision can be reached that same day. You've got the discretion, you've got the ability to push that out if you believe that additional time is necessary to fully consider the record and reach the right call. Once the final agency decision is issued, though, the clock starts ticking if the applicant wishes to appeal that decision. They have 30 days after service to file what's called a petition for judicial review. That allows the applicant to go into the general courts in the county in which he or she resides and to file a petition for judicial review with the court that basically would explain what the board got wrong, whether it was a failure to properly consider the evidence, failure to properly reach the right conclusions of law based on the evidence presented, or any other number of issues that may come up. That's the applicant's or licensee's opportunity to explain to the court why they think the court got it. It's not a time for new evidence to be presented to the courts. It's not time for the courts to do a redo of the hearing that you've already held. The court will only look at the official record, which is all of the evidence that was prepared at the board level that was considered during the deliberation of the hearing, and then compare it to the arguments that the petitioner makes to see whether the board got it right or wrong. So no new evidence, no new testimony, no new documents, but both the licensee and the board's attorney will have an opportunity to present oral arguments and written motions, written memoranda, explaining why they think the board either got it right or wrong. And then from there, the judge will either uphold the board's decision. The judge could remand the case back to the board with direction to consider certain things or to do certain things a little differently for additional hearing. Or it could reverse the decision altogether and dismiss the case. Those are really the three options that are available for the judge in that moment. The board does have the obligation to prepare the official record, including the transcript, after a petition for judicial review is filed. So we would make sure that official record is sent to the courts and the timelines set forth in statute. And then from there, if either the applicant or the board, the licensee of the board is not satisfied with the adjudication by the trial court, there's further rights to appeal up to the appellate courts from there. All right. So, as I mentioned earlier, that is all dealing with licensees and applicants for licensure. You also have the right to seek injunctive relief, or contempt proceedings against non-licensed individuals for whom we obtain evidence tending to show that they're engaged in the practice of harassment. We do that by going to the court and filing a complaint motion for injunctive relief and scheduling a hearing before the judge to present our evidence and say why this person should be enjoined from doing what they've been doing. It's a fairly common tool used by most occupational licensing boards, and it can be very effective. Because if those individuals don't comply with the court order that's duly issued, enjoining their activities, then the agency can go back in for what's called contempt proceedings, and that holds the possibility of jail time for the individuals. It holds the possibility of financial penalties to the individuals, and things get much more serious much more quickly when that happens. Okay. So that's the APA. Does anybody have any questions about any of that before I move on to public records laws?
No.
Okay, all right, I'm gonna keep chugging that. All right. So the public records laws, it's a short statute, but it's a mighty statute. It is set forth in Chapter 132, broad sweeping, that provides that all documents, papers, letters, maps, books, photographs, films, sound recordings, magnetic or other tapes, electronic data processing records, artifacts, or other documentary material, regardless of physical form or characteristics, in connection with the transaction of public business by any agency of North Carolina, is a public record. That said, there are certain exceptions to public records, and we'll get through those in just a minute. But as a broad principle of law, most boards related to the manner in which boards conduct their official business, by default, would be public records unless otherwise exempt. This includes, as I just said, electronic records, so emails, text messages, Snapchat. I don't know even what people use these days, but anything in which board business is being conducted in some manner needs to be preserved in accordance with the board's record retention schedule. So be mindful of that. Be mindful of the manner in which you maintain your board-related emails and electronic documents. It's generally good practice to try to segregate those into separate subfolders or have a separate email account set up so that, you know, if you did get a public records request, it would save the time and effort to try to go through combing old personal and board related electronic records to try to figure out which are the ones that are applicable and may need to be produced. So keep that in mind. If you have any particular questions about the best way to do that, Barton's a great resource for you, and I encourage you to reach out to him and have some of those conversations offline. There's a ton of case law on public records that's related to occupational licensing board, but there have been some interesting cases recently. There was a question that came up. This kind of touched both on opens meeting laws and public records acts, where there was a question that perhaps email exchanges between board members could, if they were exchanging emails about board business, where that could possibly be a violation of the open meeting clause, which we'll talk about in a few minutes. And this, the state of the law on that currently is that under certain facts, where if you're exchanging emails over a period of time and it's not simultaneous communications like we're having right now by video conference, then exchanging those emails wouldn't necessarily constitute a meeting under the open meeting clause. It needs to be noticed and available to the public, particularly if it's not just board members talking amongst themselves. Like if we're having conversations with board staff or with board counsel about board business, but there's not a quorum of the board members present, then while they may be public records, it's not going to run afoul of the open meetings laws. So there is some helpful guidance out there on those types of things. The The statute changed in the last couple of years on public records laws to better protect records that are issued to and from board counsel. Under the law prior to 2023, only records created by the government attorney would be exempt from public records laws, and even then only exempt for 3 years. In Session Law 2023-134, that law was expanded out, the exemption was expanded out significantly. So now it's not just for correspondence or documents from me to you, but the exchange of information is protected from public records disclosure, and that change in law eliminated the 3-year period as well. So now there's no time limit. All attorney-client privileged records will maintain that privilege beyond the 3-year limitation that used to be there. So that's an important thing for you to think about when putting things into writing. A couple other exemptions that I think are worth talking about for a few minutes are that we would commonly see with board records that you should know about. Include any records that contain trade secrets. You know, if we get records in connection with a disciplinary complaint, for instance, and the licensee sends back a lot of information to defend themselves, but there might be some trade secret stuff in there that would be harmful to the business if disclosed in a public records request. There are exemptions on that for that. Of course, social security numbers, account numbers for electronic payments, law enforcement records, criminal investigations are all exempt from public records laws. There's an exemption for sealed settlement documents, but that's not really applicable for occupational licensing boards because there's a separate statute that prevents occupational licensing boards from entering into confidential settlement agreements. So that's an important thing to remember when you're negotiating discipline, for instance. You can't tell a licensee, well, we'll resolve this through consent, but we'll just make it confidential so nobody has to know about it. Can't do that. Everything here, any consent order, any final agency decision issued by this board would be a public record subject to disclosure. You've also got exemptions to public records laws for medical records, health protected information, educational student records, transcripts or exam scores, things like that. And certain personnel records related to health are also exempt, as well as state purchasing contracts. Those are the biggest buckets for you to think about. It's important to know that a public record may contain confidential information. If it does, that doesn't exempt the whole record from the Public Records Act. Instead, it puts an obligation on the board to redact out the confidential pieces and produce the rest of the record that is a public record. So say, for instance, somebody wanted copies of every application that's ever been submitted to the board for licensure. We couldn't say, well, those are exempt from public records laws because they've got social security numbers on them. What the board would have to do is take all of those records, redact out the socials and anything else that's exempt from public records laws, and produce the redacted versions of those records. It'd be very time consuming, very burdensome for agencies, but on the flip side, it's important to be transparent with what we do. And so there's value in going through that effort to make sure that the regulated public, members of the public, have the sunshine on the operations that we do as part of state government. I mentioned the records retention schedule a few minutes ago, so let me talk about that in a little bit more detail. You can't destroy a public record unless you're allowed to do so in accordance with your record retention schedule. And that record retention schedule is set by the Department of Cultural Resources. It has about between 14 and 18 functional schedules in total. I can't remember the exact number. Each one is a bucket of types of records. And in there, it'll say, okay, board, any records related to applications for licensure have to be kept for this number of years. Any, final agency decisions have to be kept forever. We'll spell all of that out for you. And if you get to the point where, say, you gotta keep an application for 25 years according to the schedule, you get to year 26, you can delete it. Don't keep it around. That's the purpose of the records retention schedule, to help recognize when public records have lost their utility to the agency and to the public and no longer need to be retained. And so long as you're destroying public records in accordance with that records retention schedule, you're in compliance with the law. It can be burdensome to keep up with the records retention schedule and review it every year and see what records need to be destroyed and deleted. And when I say destroyed, I'm talking not only about physical hard copies, but also electronically stored records as well, on your server. But it's important to do so for a couple of reasons. One, just in this day and age, with the amount of information that all boards and agencies get, with the ease of electronic records being passed back and forth, without having that record retention schedule follow, your servers would just be enormous. I mean, that's a financial burden just to keep all of those records on your server for so many years, right? So it helps you manage the information that you've got that you're required to keep. The secondary reason is if you get a public records request and you've still got the record, even though it could have been destroyed by the records retention schedule, it's still got to be produced. So if boards aren't following the records retention schedule, you might be making more work for yourselves because it's putting more burden on you to go back even farther into records that you didn't have to keep in the first place to make sure nothing in there needs to be produced in accordance to a public records request. There's a lot of value in keeping up with that retention schedule. Your custodian of records is Barton. He is the designated custodian of records for all board-related matters. So he's the one who's responsible for going through and responding to this public records request accordingly and maintaining that record retention schedule. But even though he's the custodian of records, please do know that as board members, even after you roll off the board, there may be times when you will have an ongoing obligation to comply with public records requests. And so if you've kept your emails from your time on the board and we get a public records request asking for those emails, we may have to come back to you and say you've got an obligation, by virtue of the role you held to make sure we're getting those records back. So my takeaway to you is even after you roll off the board, don't delete all your board emails. Keep them, put them somewhere in a segregated place like we talked about, but make sure you've got them retained for the period of time that they need to be retained in accordance with the records retention schedule. And if you've got questions about that, we can talk in more detail offline as well with Barton to make sure you understand what your obligations are for that. The public records laws allow for inspection. It does not allow the board to ask why somebody wants public records. You can't even really demand that they disclose their true name and identity where they are. That's not something that they have to do in order to get the public records. You can charge for the actual direct costs for the reproduction of those records, so that if you're producing copies of licensure applications, you can charge for the cost of the printing of those applications. Not for the overhead, but for the actual costs incurred for the printing of it. If you've got the records in electronic format and can make them available in that way without having to incur the cost for printing, then that's the manner in which they should be produced. There's no hard and fast deadline for boards to respond to public records requests. I think there's a recognition to know that how long it's going to take to respond to a public records request will depend very heavily on the types of records and the numbers of documents being sought. So the law just says that you have to respond as promptly as possible. And that means fitting it into the work that your board staff is already conducting on behalf of the board in a manner in which it can reasonably be done. And sometimes they take a long time. I mean, I know there's public records requests to certain bigger agencies, some of the council and state agencies that have been pending for years and years because the requests themselves are so enormous and the amount of time it's going to take to respond to it fully is significant. So the law basically says just do the best you can in a reasonable amount of time to respond. Sometimes this board may get questions posed to it. Those are different than requests for records. So the board has no legal obligation to answer questions. It may choose to do so, but under the public records laws, that's different than asking for copies of the records that may exist. There's also no obligation for the board to create records. So if somebody asks for something that simply doesn't exist, you don't have to go type it up and give it to them. That's not a requirement under the law. There may be times, like I said, that the board does want to answer the questions asked because it's easier than telling the person, well, we don't have to answer that, but you can come look at all our records, right? So I know Barton does a good job trying to be helpful and as efficient as possible with everybody's time when dealing with questions like that. Keep in mind that particularly requests from the media, something came up involving a locksmith that generated attention from any of the news outlets. It's the board's policy not to have board members speak independently on any of those matters. So if you get calls from the local media outlets, I would direct those to Barton so that he can be your primary point of contact for answering any types of questions like that may come up. And that goes for public records requests too. I mean, you may get requests directly from members of the public. Those should all be referred back to Barton as your custodian of records. Anybody have any questions about that before I move into open meetings laws? So open meeting laws is covered by Article 33C of Chapter 143. This is another statute that's rather short but mighty. It provides that public bodies that administer the legislative, policymaking, quasi-judicial, administrative, and advisory functions of North Carolina, it is the public policy of North Carolina that hearings, deliberations, and actions of those bodies be conducted openly. Statute defines what a public body is. That is an elected or appointed authority, board, commission that is composed of 2 or more members and exercises a legislative, policymaking, quasi-judicial, administrative, or advisory function. This board is a public body, and that is why we comply with the open meetings laws. That means that anybody who wants to attend your meeting is welcome to do so. We post the date and time of those meetings both on the board's website and with the North Carolina Secretary of State Public Meetings website, where all public meetings are posted. We post, official meetings of the board, and that's defined as meetings for the purpose of conducting hearings, participating in deliberations, or voting upon or otherwise transacting the public business within the jurisdiction. It includes meetings like this that may be hybrid with folks in person and folks on the screen. It would include meetings that are 100% remote or 100% in person. The manner in which the body is gathering is not the determinant factor as to whether it should be an open meeting or not. It's the nature of what's being discussed or transacted in that meeting. Social meetings of the board are not covered by the public record, or the open meetings laws. So if a number of you went to have dinner together after a board meeting, you don't have to invite everybody from the public. You're welcome. But it is important for you to remember that you can't use that social gathering as a way to evade the spirit of the law. You can't go and talk about board business and reach decisions about board business in that social meeting. You need to remember that's not what we're doing here. This is truly a social personal gathering. So keep that in mind if you decide to be socially outside of the context of a board meeting. To properly publish an Open Meetings Act notice has to be at least 7 days in advance of the regularly fixed meeting, unless it's an emergency meeting, and that may come up because of some emergent crisis or issue that requires immediate board action to resolve that threat to health, safety, and welfare of North Carolina citizens. If that were to happen, then the board is obligated to send a written notice to anybody who has requested to have such notices from the board, and to notice the meeting, as best you can under the circumstances generally. The open meeting laws require boards to keep minutes from their meetings. Those minutes have to be detailed enough to let the public know what was discussed, what was voted upon, considerations that were made in the transaction of the business. And those are public records. It's a best practice to post those, make them available on the board's website. There's also a requirement to keep closed session minutes, but those are not public records. And they don't need to be as detailed as open meeting minutes are. Those only need to be, statute uses the term, a general account of what was discussed in the session. Enough of a description to give the basis for why the board went into closed session, for one of the statutorily enumerated reasons that they're allowed to go into closed session. They should be written in a way that, gives enough to know what was done, but also, even though they're not public records, I can't tell you they would never see the light of day, because there could be subpoenas issued to the board, there could be legal proceedings in which those become part of the public eye at some point down the road. And so it's still a good practice to draft those accordingly, with the understanding that while they're not public records, they still may be seen by somebody someday. So let's talk about some of the bases by which the board can go into closed session for just a few minutes. The biggest ones that this board would use would be to prevent the disclosure of confidential information and to consult with an attorney to preserve the attorney-client privilege. You're mostly going to do that in the context of receiving legal advice from us, or if you're going to be deliberating on disciplinary action at the close of a disciplinary proceeding to decide how you want to render that decision based on the evidence that you obtained. The board also could go into closed session to talk about qualifications, competence, performance, etc. of an employee or applicant for employment, or to plan, conduct, or hear reports concerning investigations of alleged criminal misconduct. There are more bases in statute, but those are the primary ones that this board would be using for any reason to go into closed session most of the time. To go into closed session, someone has to make a motion in open session to go into closed session. They need to state the basis, the statutory basis to go into the closed session. And then you take a second and a vote on that motion. Board moves into closed session at that point. It can invite non-board members into that closed session as it sees fit, or it can exclude everyone except the board members from participation. It's at the chair's discretion for that. The board conducts its closed session business. Votes cannot be taken in closed session. You can reach a consensus on issues, you can poll people, but if a vote needs to be taken, then the proper course is to come out of closed session by vote, and then once you're back in open session, to take the appropriate votes that were considered to have be on the table during the closed session portion of the business. And that's open meetings laws. Does anybody have any questions about that? All right, I'm going to talk about the State Tort Claims Act for just a minute, but not terribly long, since you don't have very many employees. So it's not really something that is going to come about for you with any sort of regularity. The State Tort Claims Act provides a mechanism by which individuals who allege negligence by the board or board's employees can proceed and to seek relief. The Industrial Commission acts as the court to handle tort claims against state employees or agents, and that commission determines whether state agencies or employees were negligent. And some of you may say, well, what does that mean? What is negligence? Fair question. For the purposes of the Act, negligence is defined as the failure to exercise some due care in the performance of some legal duty owed under the circumstances, and that the negligent breach of such duty was the proximate cause for some sort of injury. The most common type of state tort claims that we would see arise for boards would typically come about if you've got, say, a board inspector who's employed by the board who gets into a car accident on their way to inspect some facility or conduct some investigation. And the person who's injured in the course of that car accident alleges that the state employee was negligent in their driving and caused the accident, that type of thing. Again, I've seen maybe one brought against one board in my 20 years of doing this. So it's not a common thing that you all have to deal with, luckily. But it's good to know it's there, and that is your recourse. So these state tort claims acts are not filed in the general courts. They have to be filed in the industrial commission, and they have to be filed within 3 years of the injury, 2 years that the person who was injured died. And so there's a whole mechanism for that to be handled accordingly with the industrial commission. The board members are not employees. And while you cannot be sued in the general courts or the industrial commission for negligence, there is a possibility of claims being brought against board members for intentional acts in the general courts. So, for example, if someone were to take the position that some board action in which you voted was done out of corruption or malice or beyond the scope of the state's duties, in bad faith or willful or deliberate misconduct, those are the types of things that could arise to some sort of intentional claim in the courts. It's a really high burden for someone to allege, and not one that I've ever seen be successful in the state, actually very rarely across the country as well. It is but it's good to know it's there. And so that's why when we talk about making sure you're complying with your state ethics laws, understanding the hat you wear, understanding the need to remove yourself from any potential allegation of bias in your proceedings, that's why we're talking about it, because we want you to be above, above the scope of public perception that there was some willfulness or deliberate corruption that both of you were taking in your conduct of the board business. The General Assembly has a provision in law for the defense of state employees law. So if employees of the board were brought to court because of allegations related to the manner in which work was performed in the scope and course of their employment, then there is financial coverage available in the cost of defense from the state through those state employees. We don't have any employees. We won't spend much more time talking about that, but it is good for you to know that that is out there. This would cover claims of negligence or other types of claims that do not involve actual fraud, corruption, or loss.
So one thing.
Yeah.
A lot of guys may not realize we have an insurance policy that covers all the board members for stuff like that, allegations.
Perfect. Yeah. Did everybody on the screen hear what John said? All right. So the board does maintain D&O insurance coverage to make sure that if there were claims brought against you in your individual capacity as board members, that there's costs of defense are covered by insurance for that as well. So I tend to see sort of deer in the headlights look sometimes when we start to get this portion of the training. It's not intended to scare you, but it is important for you to know, and that's why the General Assembly is writing mandating training on the existence of these laws, so you know what's to do. All right, I know I probably kept you longer than you wanted to be talking about all of this stuff, so I'm going to finish up with lobbying, and then I promise we'll let you get back to your board business. Chapter 120C covers the lobbying laws in North Carolina. Lobbying is defined as influencing or attempting to influence legislative or executive action, or both through direct communication or activities with a designated individual or that designated individual's immediate family, or developing goodwill through communications or activities, including the building of relationships with a designated individual or that designated individual's immediate family, with the intention of influencing current or future legislative or executive action. The biggest thing that you should take away from these lobbying laws is that this board cannot lobby. There's a prohibition in 93B, which is the chapter of the general statutes that regulates all occupational licensing boards, that prevents boards from hiring lobbyists to lobby for pay. So that's set forth in 93B6. Prohibited from using any funds to promote or oppose in a manner the passage of by the General Assembly of any legislation. So that doesn't mean, though, that you as board members lose your First Amendment rights by virtue of being members of this board. It's just important that you know what hat you're wearing if you need to talk to your lawmakers about things that are important to you, which may include the practice of locksmith or the regulation of locksmith. And so you are still free to talk to your lawmakers, your legislators, to let them know your thoughts, but you need to do so in a manner in which you make it clear, I am John Jeffries and I am a locksmith and here are my opinions on this, and not to come and tell them, I'm here because the board says X, Y, and Z. You can speak as your own individual person. You cannot speak on behalf of the board if you're going to go talk to your lawmakers about things that you want them to know. So just know what hat you're wearing. And you can't claim up for any day that you choose to go down to Jones Street and talk to your lawmakers about things involving locksmith, because the board can't pay for anything involving lobbying. You should remember, though, that by virtue of your role on the board, you may be approached from time to time by individuals of the profession who have a vested interest in locksmithing and want the board to take certain positions on the regulation of locksmithing. And so just remember that you can still be lobbied. And so be very mindful if somebody offers to take you out to lunch and talk about what rules the board should be considering, or gives you a gift of some amount of value. This will all be covered in your ethics training as well. So a little bit of a forecast to you, if you haven't taken that yet, to know that this is the type of thing you should be paying attention to. So just be wary of receiving anything of financial benefit in connection with that may be somehow tied to your role as a board member for this board. Okay. All right. And that's all I have on that. So again, my line is always open. If anybody has particular questions that they want to talk about offline as you digest this material, you've got your PowerPoint presentation, so you're welcome to consider this further, read it carefully at your own leisure, and then we'd be glad to make sure all your questions are answered. So thank you for your time going through that.
Unless anybody's opposed, we'll say we take a 10-minute break. Had everybody sitting in the chair for at least an hour and a half. Get up, stretch your legs, use the restroom, whatever. We'll come back 10 minutes, carry forward. Everybody good with that? All right.
Good.
All right.
Yep.
See you.
I wish we could get that shorter, or else it just goes on.
All right, good presentation.
Run us through our paces.
Whew, that's a little fear. So you're gonna go at this rolling and then down the hall a fair bit. You'll see it on your left-hand side eventually. Yeah.
You're still recording, by the way. I don't know if that's intentional.
Yeah, thank you. I'm not sure how we pause the recording, so we'll just leave it be, but just be mindful of any conversations that occur during the break. Thank you, David.
Thank you, ma'am.
Hey, Dave, it's Eric. Just want to let you know I have a doctor's appointment at 2:30, and I may be leaving a little early. If I'm off, you guys, I just want you to know where I had to leave.
Thank you for letting
Thank you,
us know.
sir.
Okay.
You class says something that's or something to sign up for or something.
It's done
Or
through
that done through the.
it's done through the New York Government Ethics Commission.
Okay.
That's free. I don't know about members of the public taking it.
Wasn't sure that any more interest or any more information. Good, but obviously. Is it just like North Carolina class? I wish I'd search for.
Look for the ethics commission or ethics commission.
Then you were talking about a lot of classes. I couldn't keep track, but I'm assuming PowerPoint presentations just for members. It's not anything I can collect. And then you were saying something about a class for, looks like there's two, like an APA class, and then there was like a complaints APA class.
Not classes, those are just different articles is the word I used, and that's kind of like subchapters within the general statutes. Yeah,
So there's not like any classes for me.
not that I'm aware of.
Funnel through.
I'm aware
Some of this is touched on, ethics commission training. It's very duplicative.
yeah, sorry.
No.
Because I guess it's a pretty good question.
Not involved, it's,
Yeah, we used to be able to do both for the ethics training and this training, but a lot changed. Just ethics commission decided they were the only ones. It's just like, yeah, it's like 3 hours or something.
So PowerPoint presentation, whatever I can remember, whatever I can get off the line. And then,
And the board's intention to make sure this was streamed on YouTube, so it's available for folks to review later on.
as long as the issue is still. And then for the ethics class, just go to the North Carolina Ethics Commission per class.
Well, and as Brian said, I don't know that that is publicly available, or whether they allow members to.
Nice. You will reach out.
Step. Alan Perry. Perception.
I have it, but I'm going to
It's
say,
like 3:20.
yeah, no, I appreciate it. I think the cookies was gonna make me a celebrity when I get home now. That's,
They are
I'm
correctly.
definitely gonna spin that as a, you know, one of the spoils of my recent appointment.
There you go. Yeah.
I might watch that. For me, I have to stretch.
Did you? Vision contract or did you?
I can't respond because
I don't think that we need to think about all motion.
In the context of it.
I've got to take it. You ready to start that?
Wait for it. But it's like, yeah.
All right, we'll call the meeting back to order. Turn back over to Catherine.
Yeah, thank you. Thank you, John. All right, everybody. So welcome back. We're gonna turn to the second piece of business under our legal report, and that is to take a vote on the rules that were sent to you in your packets earlier this week. These rules you saw at the last board meeting and expressed a vote to move forward with their promulgation before the RRC. Now that you've got these here in final form, I'm gonna take one more vote to make sure everybody's comfortable with the language. If you have any questions about each of them, you can let me know, but I believe that these were all pretty fully discussed at the last board meeting. So the rules that you have in your packets here is 21 NCAC 290201 examination fee, 21 NCAC 290202 application requirements, 21 NCAC 29.0204 requirements, examinees, 21 NCAC 29.0206 special administration, 21 NCAC 29.0501 obligation of licensed locksmiths, 21 NCAC 29.0802. So if still likely the board to move forward with these rules as drafted, this would be the appropriate time for Mr. Chairman to take a motion on adoption of those rules.
Do I have a motion for adoption?
I'll make a motion.
Or a second?
I'll second.
All those in favor of adopting the rules as read?
Aye.
Any objections?
No.
That's all I have under the legal report. Thank you.
All right, next is, my report, which honestly, I think Bart's gonna cover most of everything, but, the hearings that we had last time, those two individuals have come into compliance. I don't think fully, but, financially both have. I'm not sure about the, no, one's had the, class that we instructed them to take. But Bart can fill us in more on that. As Catherine alluded to a little bit ago, we got some rule considerations to look over and everything else. I do want to put a committee together for that. If you guys have any interest, send Bart an email, let him know who would be interested. We have one person, Wayne Goodwin, who is on vacation today. He has not been sworn in as of yet, but he's a public member, and I'll catch him up to speed as far as if he has any interest in being on the committee once he's sworn in. But like I said, if you guys have any interest in it, we'll be going over some of the rules, some new possible rules that we'd look at. Just send that to Bart, and we'll make that determination. Whenever we get Wayne sworn in, go from there if he has interest. Other than that, we'll turn it over.
Okay, thank you, John. I report, I'll try to go in the order. Last meeting, we had two hearings, convened at 12 o'clock and wrapped up around 5 when we moved into the actual board business. And those two gentlemen, have completed, a lot of the requirements that the board, ruled on, including, like John said, reimbursing the board for investigative and legal costs determined by the board. And one of the gentlemen has taken the business ethics courses that were mandated. And I think now they're just waiting for the clocks to run out on their active license suspension. And once that time runs out, knock on wood, they haven't done anything else that violates the board's order, those suspensions will become stayed. But those orders are on the website for inspection if anybody's so curious. Okay, piggybacking on Catherine's board training, we're annually required to do that. Also, annual requirements for board members is your statement of economic interest. That's required to be filed every year by April 15th. That is found on the North Carolina Ethics Commission's website. I'll send that link to you. If you've already filed one previously, I think there's an option for a short form filing. I think it's just, 3 clicks. And you say no changes, you don't have any new offshore bank accounts and private yachts and small islands that you need to claim with the state. There is an additional ethics training that the Ethics Commission requires you to do every 2 years. I'll send that link out. A lot of it's duplicative of what we've covered today, but it's a PowerPoint and it's got quizzes and animations. And the last time I took it, this board was actually an example for one of the quiz questions. So it says, if the Locksmith board is meeting, blah, blah, blah. So, you be grateful you're part of the class. But I'll send that link out to everybody before so you can get your filings done. Don't think I have anything else. I can go ahead and cover the management contract. We do, let me see, start that sentence again. Included in your documents packet was a management contract for the board. This is just slightly a little bit more codified than our 2-page contract we're currently operating under. It just kind of makes it a legally binding contract. One party doesn't do what it's supposed to do, the recourse of the other party, things like that. So that amended contract is before you today. It doesn't include any changes to the fee structure. It just adds a little bit more flesh to the bones of what we have. So I'm happy to answer any questions. Or if they get too legal, I'll turn it over to Catherine.
If I'm not mistaken, doesn't the new one go up? No.
Fixed draft, Catherine.
So, I'll be glad to do that.
Okay.
Mr. Chair. So the draft that we sent to you with your board packet materials this week does have one correction to make to it. It didn't reflect the current compensation that was accrued in the budget for 25 and 26. So we've reflected that accordingly, just $55,000 a year, which is in line with the approved budget. So we made that one tweak to the draft you saw, but the rest of the substance is the same. And as Barton said, the purpose of this was just to make sure we're removing any, the last contract was written somewhat more informally. So this new contract tries to remove any ambiguities and clean up the wording that you would typically see for a contract to make sure both parties are advised of their legal rights and obligations under it. But we didn't change any of the substance of what your management contract company does for you and what you would expect any of your obligations back to them.
The only other thing changed was what the old 30 days of notice.
I think we tried to clarify with what the correct practice has been. But Barton can probably speak to that a little bit better than I can.
Contract hasn't been under inspection for a good.
Well, I thought it was only made thing. To me, as I recall, it was the notice termination from either side was 30 days in the old way, and now it's 90 days. Which I could be wrong in my memory, but I think that's what it was.
No, I mean, that can absolutely be.
That just, in my tenure here, we went through a situation where 30 days gave quite a pucker factor to the board when we were at risk of losing Bard, Randolph Cloud Associates, had given the board notice. So that's extended that out to make it, if we ever get that point again, wouldn't be as scrambling of a time factor.
Continuity of operations.
Yeah. So, all right. So we're gonna make a motion for approval. Have a motion for approval of the new.
Motion to approve.
All right. A second. I think Jack's got a second. Yeah. All right. All those in favor?
Aye.
Any opposed? So we'll approve the contract. Yeah. Any else for it?
No, sir.
Go to the education exam committee.
All right, thank you. I will be proctoring the exam April 18th, which is in Asheville, and I appreciate the new time, 10 o'clock. Thank you, thank you, thank you. The last exam was in March, and I believe Eric and David done that. Do you have any numbers, fails, pass, comments, concerns?
We had 26 show up out of 28, I believe. As far as the passing, Eric, do you have those numbers?
Yes,
You're on mute, Eric.
Looks like that will. Some streaming issues.
Yeah, it's probably streaming. Mine's a little slow as well.
okay. I think I'm off mute now.
Yep.
Okay.
Good.
We had several individuals that passed, had 2 no-shows. Then we had 5 that didn't make it, I believe. Am I correct, Martin, on that? But everybody did well. We had one guy show up a little bit late, but he made it on time. But for the most part, we did we pretty much spent the whole 3 hours there.
All right.
Yes.
Thank you for doing that.
Okay.
I did want to report on something that was brought up by one of the people being tested in our. It looks like in the study guide, we have one of the questions that has 2 letters representing the correct answer, a shoulder stop on a key. That's something I think we need to look into.
What question was that? What do you remember the number?
I can't remember off the top of my head, but I'll have to look at the study guide, but it was a question related to what letter represents the shoulder stop on a key blank. It had an illustration of a key blank and 2 different letters, one pointing to the top of the shoulder stop, one pointing to the bottom of the shoulder stop. So that's I think something we need to correct.
Okay. Okay.
If you'll send that to me, I'll make that correction and make sure the next batch has that information.
Yes, sir. I'll shoot you an email on after the meeting.
Anything
And
else?
that's it in education.
All right, move to unfinished business. Any new business? All right. Then, like I said, just to reiterate, we got a new member, you haven't sworn in yet, Mr. Goodwin. Hopefully before next meeting, we'll get him sworn in. And if you have any interest in being on the rules, I guess, review committee or adoption committee would be properly termed, send it to Bart and let me know. So we get that formed and then kind of get ahead of the cart on the issue coming for us. Other than that, I appreciate everybody being available today. And if you have any questions of me anytime, point in time, just feel free to reach out. If you don't have a current roster, send those to Bart and he'll send you. I'll entertain a motion to adjourn.
I'll motion.
Have a second? All those in favor?
Yeah.
Aye. Opposed? All right, we stand adjourned. Next meeting, June 3rd. Thanks,
Thank
guys.
you.
Thank y'all. Bye-bye.
Thank you all. Take care.
Therefore, have a great week, guys.
You too. Bye.